Perfect. Thank you.
Ladies and gentlemen, we're here today with our breakout session. We have with us today Dr. Preminger from Cardiff in the UK, and we have Aibak Hafeez with us from the University of Illinois, Urbana. Dr. Preminger is a lecturer in human resources management at the Cardiff Business School, an author of Labor in Israel, Beyond Nationalism and Neoliberalism, published in 2018. Dr. Preminger studies industrial relations, organized labor, and employee ownership, focusing on issues of allocation of power, inclusion, democracy, and citizenship. Aibak Hafeez obtained his bachelor's and master's degrees in management sciences from the University of Punjab in Pakistan. He has received a scholarship and is currently a doctoral student at the University of Illinois Urbana-Champaign. He just went through a round of dissertation defenses, which is a very stressful experience for anyone. And his studies focus on controversies and debates related to arbitration and mediation used as alternative resolution mechanisms. Aibak is expected to complete his degree this summer, and we certainly wish him the best with that. Dr. Preminger is going to talk to us today about the concepts related to centralized bargaining and the use of judicial systems for the resolution of disputes in the labor and employment area in the state of Israel. Dr. Preminger has a recently published paper to present, and I look forward to listening to what you have to say. Doctor, the floor is yours.
Thank you very much. I'll just share this then, and we should be okay to go. So it's great to be here. It's a shame it's online, but that's the way it is these days. I'd like to begin just by emphasizing that this is a paper that was written by my co-author, Assaf Bondy from Tel-Aviv University. And we've both been studying industrial relations in Israel for quite a while, as you can see from my book here, which was so kindly mentioned and which I'm shamelessly promoting. And in many ways, the things happening in Israel are similar to things that we see elsewhere in this field, but the country's history of a very robust corporatist labor relations and its ethno-national underpinnings to this corporatist labor relations makes it in some ways quite unique. And in other ways, a very good case for exploring issues that we see manifested in quite an extreme way. So the paper looks at juridification and its impact on collective industrial relations, which is a very common industrial relations theme, but we think we identify some rather interesting developments. The context then is, of course, the decline in general, the decline of collective industrial relations and the increase of juridification, which is basically central state regulations gradually substituting for collectively bargained norms. And we see this manifested in the increasing importance of lobbying, litigation to address workers' grievances, to enforce rights, this kind of thing. And we see this happening in both pluralized and decentralized systems like the US and the UK, and in corporatist, more centralized industrial relation systems, as we have in Israel, Sweden, Germany. These are well-known corporate states, so where we have much stronger level of peak-level tripartite bargaining, where the traditional social partners, the unions and the employer organizations have a much more dominant position, much more certain status within the political constellation. And Israel is a very clear example of this kind of system. Now, in corporatist system, we see juridification in the decentralization and shrinking coverage of collective agreements, among other things, and the increase in the use of labor courts to settle individual disputes. We also see increasing intervention of the labor courts in the processes of collective bargaining or collective labor disputes. Now, sometimes we see traditional industrial relations actors adopting new strategies to try and counteract these kinds of trends, but they often fail to push back against juridification, and thus they open the way, or this opens the way for the increasing involvement of new industrial relations actors, non-union actors, who rely more on legal strategies to advance the interests of their constituencies, and their constituencies are often workers who were previously excluded from the more traditional collective union representation. So unsurprisingly, non-union workers are more likely than union members to benefit from this juridification, judicialized forms of resolution, of dispute resolution. And this further emphasizes the dividing line between the employment rights regime and collective labor relations, but also between unions and these new industrial relations actors. Of course, unions sometimes adopt what we might call judicial strategies as well, and cooperate with these new industrial relations actors, representing individuals, submitting cases to court, this kind of thing. But union funds are limited, so we often see the new industrial relations actors getting the lion's share of such judicial cases. And of course, juridification can be costly for employers as well. They face expensive and time-consuming claims, and it can be very slow because the labor courts or labor tribunals end up with a backlog and become inundated with these kind of individual cases. But regardless, in general, these trends challenge the collective underpinnings of industrial relations, and the entrance of these new industrial relations actors tends to undermine the union's monopolistic dominance in the field. Now, union revitalization literature is really what's looking at the strategies of unions to counteract these kind of trends, but we have to remember that the employer organizations are very important. They're the other side of the coin, particularly in these corporatist industrial relations systems. So we're looking at both sides of the traditional class conflict. And this is true because in these corporate systems, we often find that membership is not really so crucial, or not perceived to be so crucial for maintaining collective bargaining, because these traditional social actors had the support of the state, the patronage of the state for their role. And so the social partnership faced fewer challenges, and neither the unions nor the employer organizations were really seeking its demise. However, in such centralized systems, even though the social partners still have this important role, they're also increasingly alienated from their members because centralized collective bargaining is seen to come at the expense of inclusiveness and to undermine the voice of workers and employers, actually, who then seek alternative representational forms. And this, of course, impacts the social partners' ability to influence the employment relationship and their ability to promote socioeconomic inclusion. In the context of a strong corporatist institutional legacy, then, we would expect juridification to spur both unions and employer organizations to change their strategy in some way. Now, this change might not be able to reverse juridification, but we could expect it perhaps to rebuild the dominance of the social partners through the adoption of new legal strategies, new political norms, individual inclusion, representation, new strategies of enforcing employment rights and this kind of thing. So in this paper, we're exploring the ways the traditional social partners responded to these kind of threats and the pressures in a strongly corporatist sector, which is the construction sector in Israel. This is a very important sector. It was formerly highly unionized and mostly publicly owned, but now it's been completely privatized. Nonetheless, this legacy of corporatist governance has left collective labor relations relatively intact. Labor regulation is still based on sectoral collective agreements signed between the Israeli Trade Union Federation, known as the Histadrut, for those of you familiar with it, and the Sectoral Employers Association. And they're usually extended to cover the entire sector. And this grants the social partners, traditional social partners, with very strong institutional security. So we have the strong corporate structure and institutional legacies, but we also see that the structure and the position of the social partners are being challenged by unorganized, cheap labor and the gradual inclusion of non-citizen Palestinian workers who have become the dominant group of non-professional workers in this sector, in the construction sector. Now, for reasons I don't really have time to go into, non-citizen Palestinians benefited from very few of the collectively bargained protections, even though they were formally covered by these agreements. And the Histadrut, the Labor Federation, refrained from organizing them, refrained from representing them. And so we can say that de facto, the Palestinians were excluded from normal employment relations within this sector. And therefore, it was really the civil society organizations and private lawyers who opened the way for non-citizen Palestinians to bring their grievances to the labor courts. And this made these particular actors quite dominant in enforcing the rights of precarious workers and really pioneering processes of juridification. And we see that cases of litigation rapidly increased, and this placed a heavy burden on employers and the courts. So in many ways, this is a very typical case of corporatist industrial relations being challenged by processes associated with juridification. So the response here, the social partners, facing these challenges from below, and the CSOs, the private lawyers, and also from above in the form of court intervention, which I didn't really mention. So they responded to it by setting up an enforcement committee. So the employer organization and the Histadrut, the Labor Federation, set up this committee. And this was basically an arbitration framework, which involved these two traditional social partners, and it was recognized by the labor courts as an obligatory first step in any dispute before that dispute could be brought to the labor courts. I don't know if you can see very well in the diagram here. This basically shows the process of using the arbitration mechanism and the possibility of then taking the dispute to the courts. So basically a case is brought by the worker, the employer or the labor court proposes that the enforcement committee be used instead of the court. The parties then accept the committee's decision and the case is closed, or they don't accept the decision and the case then goes on to the labor courts. So the committee is a substitute for judicial arbitration, but importantly, it was initiated by the social partners and anchored in a collective agreement. So it asserted the social partners' precedence over independent litigation and subsumed this kind of legal logic within these collective frameworks. And after being established, it did become very busy quite quickly. Now, in cases where the dispute did nonetheless reach the labor courts because one of the sides didn't agree to the decision, we see that the courts often take the committee decision as the basis for their ruling. I apologize for a very brief presentation of the empirical material, more details in the paper. So just very briefly then, what I'm really trying to say here. There's a lot of literature which discusses the collective industrial relations and juridification as being mutually antagonistic forms of regulation of the employment relationship. But there's a little bit of literature, and we're kind of placing ourselves here, which suggests how these two regulatory approaches and logics might coexist. Now, we should emphasize that the renewal of the social partnership through this initiative doesn't have any impact on wages or union density. Instead, we see how they're facing external pressures and challenges to the collective regulation from juridification, from these new industrial relations actors, and they're taking these concrete steps to improve enforcement strategies and thus really address the issue of internal legitimacy of the traditional social partners. And it enables them to legitimately represent their constituents, and importantly, including the non-citizen Palestinian workers and their employers, of course. And they do this through a mechanism which is anchored within the collective industrial relations institutions. Now, others have argued that the juridification of industrial relations can perpetuate inequalities between insiders and outsiders, members and non-members, because insiders, of course, have better access to the system, probably superior understanding of how the system works. But here we see that the case that we're presenting here, it was the combination of this sort of workers' rights or human rights logic with the institutional power of the social partners that broadened the union's constituency and decreased inequality between insiders and outsiders, between the Israeli workers and the non-citizen Palestinian workers. We should also note that though the new framework does sort of subsume individual workers' voices and grievances within these collective frameworks, the social partners nonetheless kept these basic exclusionary principles of Israeli industrial relations. They didn't adopt any sort of bottom-up organizing, bottom-up strategies for sort of organizing these precarious workers within the system. So we don't want to overemphasize where this could be going. Nonetheless, the case does have implications, we think, which go beyond the relationship between juridification and collective industrial relations. Firstly, by reasserting themselves as dominant regulators of the sectoral labor market, they also strengthened the position of collective bargaining at the sectoral level. So they neutralized this tendency to what some have called organizational primacy, this idea that, that the organization becomes the key focus for employment relations, and they're bringing it back up to the sector level. So they're neutralizing this tendency to think of employment relations as a workplace issue, which is also a process associated with the undermining of collective labor relations. Also, the mandatory arbitration of labor disputes has actually been called a key example of this kind of organizational primacy, because it allows the employers to determine the process of the enforcement through which individuals can sort of pursue their rights vis-a-vis the employer. But in this case, we see the social partners creating a mechanism that ensured that the logic of individual rights at the level of the workplace was channeled through a collective sectoral level framework. The paper also underlines the importance of context and the position of the trade union within specific legislation and norms. So we can see that in decentralized systems, unions are often overwhelmed by litigation because we see employers trying to avoid this kind of collective frameworks. And we could see that in such cases, the juridification embodies this line of conflict between unions and employers. But in the context of corporatist institutional legacies, we see how this conflict can be contained within the sphere of the social partnership. So where the union has what we might call historical institutional support or strong institutional legacies, employers are more likely to engage with the unions in addressing individual disputes within these collective frameworks. So to summarize then, we asked basically how these processes of juridification can impact the structures and frameworks of collective labor relations. Using this case study from the Israeli construction sector, we suggested that a rights-based view of the employment relationship can actually be complementary to collective interest representation. In other words, these substantive employment rights, even human rights, can be anchored within these collective institutions. Also, the framework initiated by the social partners, what we've been calling this enforcement committee, strengthened the position of the social partners within the IR system and re-established their primacy or dominancy over alternative representational forms, so over these new industrial relations actors, at least to a certain extent. Again, I don't want to overstress this because these new industrial relations actors are still active. And this mechanism adopted the logic of statutory regulation and juridified representation to enhance the status of these organizations vis-a-vis the state and the legal system, and also enhance their status in the eyes of their constituencies, employers and non-citizen workers. And crucially, it facilitated the inclusion of workers who were previously excluded, these non-citizen Palestinians. And this would have been unimaginable in the relatively recent past. However, in establishing this enforcement committee, the social partners accept a legalistic framework of justice. So this development, this initiative is unlikely to do much to nurture a more collective narrative of injustice, or a kind of injustice that might help revive a collective framing of the employment relationship, because they've accepted this kind of logic. So to conclude then, juridification has significant potential. We're suggesting the literature suggests to negatively impact centralized IR systems and the development of inclusive collective representational structures. But we're suggesting that its logic can nonetheless be compatible with social partnership, and this specifically where two conditions are met. Firstly, where there is still strong institutional support for the social partnership, and secondly, where the social partners agree that they need to act against expensive and time-consuming manifestations of juridification. So under these kind of conditions, we could expect that the collective industrial relations system is capable, would be capable of subsuming the logic of the employment rights regime. And as mentioned before, since submitting the abstract, the paper has been accepted to a journal and even published online. So we're very happy to invite you to read the full story as well. So thank you very much for listening, and happy to take questions, of course, if there are any. Thank you.
Doctor, thank you very much for that explanation and illustration. We appreciate it very much. We're going to hold off for questions until after our next presenter has the opportunity to give his address. Now, ladies and gentlemen, after hearing Dr. Preminger's insightful analysis of the relationship between what I refer to as master labor agreements within sectors and the interaction with judicial mechanisms for resolving labor and employment matters, discussion of the interaction between the two, we're going to move now to a discussion of something that is more specific, having to do with the manner in which employment disputes are resolved. Mr. Hafeez is going to talk with us about the analysis that he has undertaken of post-dispute voluntary adoption of arbitration as an alternative to traditional litigation in the American sector. And he is going to use the FINRA system as an example. Mr. Hafeez, the floor is yours.
Thank you.
Speak up, please, sir.
Yes, can you see my screen?
We can see your screen and we can now hear your voice. Thank you so much.
All right.
Please carry on.
Okay. So, yes, thank you for that introduction. I am basically going to be talking about resolving statutory discrimination claims in a post-dispute voluntary arbitration system. And like Zan said, I use data from the securities industry. So as Dr. Preminger was talking about pre-dispute mandatory arbitration, he was alluding to the fact that, you know, it does have controversies and criticisms associated with it because it is a contract of adhesion and employers basically enforce it upon their employees, which makes it sometimes people call it as an assault to employee rights, especially because employees are being forced to have their statutory cases heard within this private arbitration system. So because of these debates and these criticisms, advocates of arbitration came up with a solution in the name of post-dispute voluntary arbitration, where employees are not forced to use arbitration. Rather, they have the choice to opt and use arbitration. And there's an option of using litigation at the same time. So they have both options, arbitration or litigation. Now, if you look at this at face value, it seems to make sense and it seems to be fair, but the literature shows that post-dispute voluntary arbitration also is, it also has issues and there are a lot of criticisms regarding this system as well. Primarily, Stryker and also Sherwin talk about the main problem, which is to do with the decision to use arbitration in this system. They contend that if there is in a voluntary arbitration system, both parties will not mutually choose arbitration, and most of the times, if not always, all the cases will go into litigation. Now, this is one school of thought, and they explain this using theory as well as some survey data of lawyers in Chicago. But Lamar and Lipsky also have conducted some studies on the securities industry, where they show that after post-dispute voluntary arbitration was adopted in the securities industry in 1999, the arbitration cases did drop, but they did not reduce to zero. So what they show is that arbitration is still being used. So nonetheless, like even if that is true, there are scholars who still think that post-dispute voluntary arbitration programs do not fix the problems associated with employment discrimination law adjudication. And they think that voluntary arbitration system is not viable, and it should not be implemented at all. This debate regarding post-dispute voluntary arbitration is mostly descriptive, and people have just talked about it without any empirical evidence. So this is the kind of gap I am trying to fill in the literature. I'm using empirical data from the securities industry to get to this question. Specifically, I examine and compare how the usage and case dispositions vary in a voluntary arbitration system where you have arbitration as well as litigation as an option. I use discrimination cases specifically because those are the only kind of cases that can go in that FINRA allows to be taken into arbitration or litigation. All the other kinds of cases you have to arbitrate. And I cover the period from 2004 to 2017. Once again, my arbitration cases are from FINRA. And my litigation cases, I collect data for federal and state court cases. Now, the way I collect the litigation cases is that for all the firms in my FINRA data set, I go into Bloomberg Law and I find the discrimination litigation cases against those firms as well. So at the end of the day, for each firm, I have all of their discrimination cases, whether they were arbitrated or litigated. My independent variable for the dispositions analysis is forums. So there are two forums, arbitration and litigation, 0 being arbitration and 1 being litigation. My dependent variable is like, here I would like to say that most of the studies, they talk about outcomes in terms of, a binary variable, employee wins or employee loses. I try to include a third category in disposition, which is settlement, because Schwartz, for example, says that this category of settlement is really important, especially with respect to litigation, because in order to do conduct a comprehensive analysis or comparison between the two forums, you have to take into account settlements, because that's one of the primary dispositions in litigation, in the litigation system. So not incorporating settlements, I think, skews the results a little bit. So once again, does voluntary arbitration serve its purpose? This is the macro level question of this paper. In doing so, this paper also contributes to the literature that compares arbitration and litigation in general. Most of the studies up to date have compared arbitration and litigation. They've compared arbitration when it is mandatory in nature, because that is the most prevalent form of arbitration being used, especially in the US. So although that comparison is important, but I'd like to get to the question of whether arbitration and litigation, how they compare with each other when both of them are non-mandatory. And that will let us get to the question of whether arbitration, it's considered to be inferior, but is it inferior in and of itself, or does it does making it mandatory cause the problems? So it might be the case that arbitration is a good system. It's just that when you make it mandatory, that is when all these fairness issues and these justice issues come up. So, I mean, I'm not concluding this, but it might make sense to have arbitration as a voluntary system as opposed to a mandatory system. So my first hypothesis is derived from Sherwin and Streicher, where, like I explained, they talk about that arbitration will not be used in a voluntary arbitration system. But then I also explained that Lamar and Lipsky explained in their papers that arbitration usage decreased, but it did not drop to 0. What I want to get at is, like, what is the comparison between these two forms? So Lamar and Lipsky talk about this question within the arbitration forum. I compare arbitration with litigation to see whether there is a difference in usage between these two forms. If there's, for example, a higher usage of arbitration, that will obviously show that parties tend to go towards arbitration when there is an option. The second question, the second hypothesis is linked with dispositions. So the first part is that I think that both these forums, arbitration and litigation, are distinct forums, and they attract different kinds of cases. So, for example, in arbitration, it's a more congenial, it's an informal, comparatively informal system compared to litigation. So, for example, cases that have low cost, low stakes, they would probably go into arbitration, and they would probably win in arbitration if you look at it from the employee's perspective. And it wouldn't make sense for any of the parties to take such a low cost case into litigation, because the costs that they would incur in a litigation forum it wouldn't make sense for those cases to go into litigation. So I contend and hypothesize using my data that the likelihood of employees winning is higher in arbitration compared to litigation, and the likelihood of employees settling is higher in litigation compared to arbitration. Because litigation is all about settlements. Most of many parties go into litigation thinking, like, from an employee's perspective, that there will be a high settlement that they can get from a litigation forum. But in arbitration, settlement is not the most positive prevalent disposition. So winning is the most positive prevalent disposition over there. So they take those kind of cases into arbitration. This is the summary statistics by forum. I'll get back to this when I'm discussing my results, but you can see that the case characteristics over here, they have a star. It means that they are quite different between the two forums. So these are all the variables I use for my regression analysis. I'll talk about them in the next slide, the slide after this. So to get to the first hypothesis, we can see that the average arbitration proportion for each firm. So the arbitration proportion, the first column, the second column, I should say, shows the average proportion of arbitration cases that were taken into arbitration. For example, for AG Edwards, 70.59% of the cases were taken into arbitration, and then 29.41% were taken into litigation. Now, if you take the average of all these firms, we can see that the average proportion of cases that were taken into arbitration were 32.66%, whereas for litigation, it was 67.34%. So we can clearly see that that parties are more likely to take their cases into litigation when they have an option of going into arbitration. But by saying this, we should also acknowledge that arbitration is still being used at a 30% rate. Now, this is the result for my dispositions analysis. So here I used a multinomial logistic regression because I have three dependent variables. The dependent variable is disposition on the left-hand side. So we see employee wins at trial and employee loses. And we have the independent variable, which is forum. I have arbitration over here, and the reference category is litigation. I won't get into the details of this framework, but overall we can see that the coefficient beta over here, it shows that the relative log odds of employees winning at trial versus losing, the orange row over there, significantly increases by 5.180 if they file an arbitration claim compared to a litigation claim, right? And similarly, so this was for employees winning. Similarly, for settlements, we can see that the relative log odds of settlements significantly decrease by 3.630 if an arbitration is filed instead of a litigation case. So this basically supports my hypothesis, my second hypothesis again, that litigation is all about settlements. So arbitration is all about winning. So that is what goes on in reality as well. Now, all these results basically affirm that arbitration and litigation are indeed two distinct forms, like my this table shows as well over here, I was mentioning, and that both these forums basically the cases self-select into these forums so that they can, appropriately get to a resolution. Both forums are used. My first hypothesis basically shows that, I enforce that both forums are used when given an option to select one, but I do find that litigation is preferred. Now, does all this mean that litigation produces better results for employees? I think this is where the big question surfaces. Which forum is better? We talk about this all the time. Is arbitration better or is litigation better? But my big question is that, is this an appropriate question, that which forum is better? I think it should be which forum is better for the case at hand, because both forums attract different kinds of cases, and they produce different kinds of outcomes as well. So it's not that one forum is better than the other. I think that both forums should coexist, and this is why arbitration exists is still existing in the first place, although there's a lot of people in the Congress trying to get rid of it. But it's still there, and I think it's there to stay. It's just that we have to think about the dynamics, that's the policies that we are implementing to keep it in place. So overall, I feel like post-dispute voluntary arbitration programs may not fix all the problems, like Sherwin mentions, associated with employment discrimination law adjudication, but it does address some of them and therefore does serve its purpose. So that's my overall thinking about arbitration, litigation, and this voluntary arbitration system that we have in some of the organizations in the US. Thank you.
Mr. Hafeez, thank you so very much for your observations and analysis. I'm going to come back to you in a few moments. I'd like to direct a question to Dr. Preminger first. But before I do that, I've been reminded that I was remiss when we began the program by failing to say, who in the world are you? Well, I am Zan Blue. I am an attorney with Constangy, Brooks, Smith, and Prophete. I practice labor and employment law in the United States and have been doing so, well, for only 40 years. I've represented all kinds of employers in administrative forums, state court, federal court, pretty much any forum you can describe. And I currently spend most of my time giving strategic advice and discussion to employers. So that's who I am, and that's how I came to be here. Now, Dr. Preminger, a question for you. You've described the comparative analysis of a sort of centralized bargaining mechanism within an industrial sector, and using that sort of mechanism to resolve employment issues, versus the term juridification, which I interpret to mean the use of traditional judicial mechanisms to address the same sort of thing. Now, in the United States, there's been a fervent debate about the reasons for the decline of influence of labor unions over the last 25 years. One of the hypotheses put forward by certain elements of the community are that the creation of individual rights to be enforced through litigation in the judicial system has been a major contributor to the decline of union influence. Based upon your study and analysis of the process of centralized bargaining and collective relationships within a sector versus the use of a more traditional judicial system, what do you think the impact of this interaction is upon the relative influence of labor unions within the social construct?
If I understand your question correctly, first of all, you're comparing it with the US, which, yeah, I mean, it is a very different system, and I agree that it will undermine the collective aspects. But I think what the question is skirting around partly, and this is actually the question I had for Aibak as well, is not just what are the forms that we're using to push a particular agenda or to ensure rights or to deal with grievances and other labor disputes, but also what are the implications of that in terms of our understanding of justice and our understanding of our place as workers and what we're supposed to do there and what kind of rights we should have. And I think this is another layer which we mentioned very briefly in the article, but it's not really about this, and that's why I didn't present it here. But I think this is a question that lies underneath your question. Now, in the corporatist system, no, let's say in the Israeli system, let's not go too generalized here, but in the Israeli system, there's a lot of legitimacy and a sense of the rightness or the justice of this collective way of doing things. And this is partly because of the history of the labor or movement within Israel's history and the establishment of the state, and partly, like I said before, the institutional legacies of a very robust system. Having said that, there's also the legacies of the ethno-national underpinnings of the system, which I mentioned but didn't really go into. But of course, it's always there as soon as you talk about outsiders to the system, and these outsiders are non-citizen Palestinians within a corporatist system of insiders who are Israeli citizens. There's another layer of complexity, which is of Israeli citizens who are Palestinians, who have another position within this constellation, but I don't want to complicate it too much. I haven't directly answered your question, but I think that this is an important aspect of your question, and I think this links very well to Aibak's piece presentation, and I'll leave it there. But I will have a question for him about this as well.
No, very good. Now let's turn back to you, Aibak. Let me make sure I understand the foundational circumstance that you've described. As I understand the FINRA system, in the securities industry, many of the employees are required to agree to resolve their employment disputes through an arbitration system. That is sort of the default. However, the system has been revised in recent years such that employment discrimination and harassment claims are subject to an opt-out. So while the employees in the industry, or many of them, are required to use arbitration as the default position to resolve disputes, the employee wishing to present an employment discrimination or harassment claim can opt out of the FINRA mandated arbitration and use the judicial system. So that is where we get into the post-dispute voluntary mechanism for FINRA. Do I understand that correctly?
Yes, and just one caveat to this is that both parties have to agree to not use arbitration or to use arbitration. It's not like it's only the employers who can make a unilateral decision.
Right, and that's the default position across the industry, which
Yes.
is, I believe, unique in United States industry across the board outside of the collective bargaining context. So with that just sort of clarification note, Dr. Preminger, what would you like to put to Aibak?
Well, I was thinking that your presentation was very much a snapshot of a particular situation, and yet I would imagine that many of the things you're talking about have sort of follow-on impact. So if, for example, you get a run of successful from, let's say, the employee's point of view, get a successful run of arbitration, would that push people towards arbitration? And as Zan mentioned, there are regulatory frameworks which push in a certain way, but there are also norms that push in a certain way. And I would expect these to change over time. And the norms will probably affect success as well. So success, you know, I don't want to talk about litigation, which I don't really understand that much, but certainly arbitration success is also dependent on what is the norm given a particular circumstance, and these norms change in light of previous successes or failures or trends within the system. So the data, and this relates to what I was talking about with concepts of justice and how these would change depending on the dynamics within these two institutions that you mentioned. Now that the data you've presented today, of course, doesn't capture this. So broadly, my question is, do you have other data that does capture some of this and how it might impact the things you're looking at?
So you're getting at to the idea of justice, right? Is that what you're asking?
That's almost a side issue. I guess I'm getting at the idea of context here. Context more broadly and how that affects what people are likely to do, and also affecting understandings of what success looks like, and what kind of success we're going to be pushing for when we go into arbitration.
To comment to that, I'll first, like to kind of repeat what I was saying, that the context of the case, and there must be a whole host of other variables that affect the decision to arbitrate or litigate. And let me tell you, there's a lot of it has to do with the lawyer as well. You know, there's and Zan would know more than me about this, obviously, that sometimes there's a conflict of interest between the lawyer as well as the employee, employee plaintiff. If the lawyer deems appropriate, if it makes sense for the lawyer sometimes, now this is like a cynical view, but the lawyer might want to take the case into litigation so as to, like, yield a bigger return somehow. But maybe the employee wants to just go into arbitration, get an appropriate award if he or she can win, and then get done with it. But yeah, like overall, generally speaking, like talking to different people and implications of my results, basically, if I interpret them, it shows that cases that are not very big, not very meritorious, not very complicated, both parties don't like to take those cases into litigation. And other scholars have, like Schwartz, Streicher, Sherwin, have also talked about this. It doesn't make sense to do so, right? If I have a case which I think will not make more than, let's say, $100 for me in litigation, and I'm going to be spending $200 over the whole process, it doesn't even make sense to do that. Whereas in arbitration, it's mostly, you just have to pay for your lawyer mostly, and the rest of the cost is borne by the employer. So it makes sense for those cases to go into arbitration. But if the case has meat to it, has weight, the employee would certainly want to go into litigation, and maybe to get a high settlement or something. And the lawyer and the employer probably would not want to go into litigation if the employee has a strong case, but then they would try to settle the case. So so yes, if I'm understanding your question properly, context does matter. And you were talking about justice a little bit. I obviously cannot get to that answer with my data, and I don't think anyone can as of now, because we just have data on outcomes. There's a whole host of variables and things that go on when the dispute actually starts. So an appropriate study would be to go into an organization, sit in one of their offices, and look at each and every dispute from the point it starts till the end, and have a post-voluntary arbitration system to see which case goes where, which case settles when, and look at the life of the dispute. And that's how we can get to the concept of justice, but we can't do that with this kind of secondary data.
I thought that was an excellent answer indeed. We have approximately 4 minutes left. Let me pose a question to each of you. Our program has been discussing mechanisms for dispute resolution, ranging from the broad scale conversation offered by Dr. Preminger and the more granular, discrete dispute resolution process discussed by Mr. Hafeez. In the United States, once upon a time, the Supreme Court talked all the time about a national labor policy encouraging prompt resolution of disputes. And as someone who's practiced in the judicial system for a very long time, I can testify without fear of contradiction that the judicial system's resolution of disputes is anything but prompt. Feeding off of the issue of justice versus resolution, what should be the objective of a dispute resolution mechanism in the labor and employment relations sector? What should the objective be? Is it justice? Is it resolution? Is it policy implementation of individual rights? It's a totally unfair question, and I feel great being able to pose it. Doctor, what think you?
Feel free to jump in.
I'll just say one or two words after you're done. It's okay.
Well, funnily enough, this was also something that I was thinking of when Aibak was speaking, and he partly answered it when he went into more detail about what employers are likely to push for and what employees are likely to push for. But I think it's important to remember that they don't always have the same idea of what the desired outcome would be. Now, Aibak talked about that in quite instrumental terms, in terms of, numbers of dollars. But of course, there are other ways of thinking about what a successful outcome might be that isn't just instrumental in terms of the amount of compensation I'm getting for whatever grievance I've had. And I think this could well be the major difference between individual litigation or individualized processes and collective processes, which collective processes have a very different idea of what justice might look like. So I'm not answering your question directly because I never do that kind of thing, but I think it is interesting when we consider the pros and cons of these different systems. If you have an arbitration system, which is like the one we've been looking at, somehow under the wing of the collective frameworks and collective understandings of what justice and workers are, they will produce very different outcomes from the same system, but in a completely different context, which is another reason why I wanted a bit more information about Aibak's context.
To answer your question quite directly, Zan, I'm going to try. I think perceived justice and procedural justice, these are two things I would like to say. Now, what I'm trying to get at with the post-voluntary arbitration system is that at least it has some kind of procedural justice, right? Employees are given an option to choose between arbitration and litigation. When they are forced to do arbitration, even if arbitration is good for their case, they will still be like, I did not have an option, and they will not feel that that concept of procedural justice, and that will then affect perceived justice as well. So I think at the end of the day, satisfaction is key. I mean, if I don't have a meritorious case and if I don't win, at heart, I will feel that justice prevailed, and I would perceive justice. So I think these are two key concepts that I think I, at least as a student of this field, think that that should be the main goal.
I think that's an outstanding answer. Gentlemen, I want to thank you very much for taking the time to do all of the hard work to prepare for today's presentation, and to thank you for all of your efforts put forward to get this thing put together, and for your very excellent presentations. I hope
thank you to Zan and Laurie as well, who I know behind the scenes have done quite a lot of work getting this up and running. So thank you to you guys as well.
Well, Laurie has done a great deal of work, most certainly to keep me in line, which is no easy task. And Bernadette and Emily always do a great job. So again, Aibak, Jonathan, thank you both very much for your time and your efforts. We all appreciate it very much. And with that, I will say good day.
Bye, Dr. Preminger. Bye, Zan. Bye, Laurie. Thank you.
Bye-bye.
Bye.